Welcome to Reflections, a program where we discuss values and virtues for the transformation of the individual and the society at large. My name is Father George Ehusani, and today I have with me in the studio Professor Epiphany Azinge. Prof, you're welcome.
Thank you, Father. Nice to be here.
Thank you. Professor Azinge is a legal luminary, professor of law from the University of Benin, and after many years at the University of Benin Law Department, he moved to the Nigerian Institute of Advanced Legal Studies, where he became the Director General and retired only recently, right? And Professor is still very active, apart from having his chambers, Azinge and Azinge. Oh, your wife is also a lawyer. Yes. Chambers, legal outfit. He is a member of the Commonwealth Arbitral Tribunal that is based in the UK. Commonwealth Arbitral Tribunal. You will tell our viewers what that tribunal is all about, because I'm hearing it for the first time. So, Prof, you are welcome to the studio.
Thank you very much.
And today we want to take on the whole issue of law and the role of law and lawyers for national development. For many years myself, I have been in my work in the human rights community, in the pro-democracy community. I have worked a lot with lawyers, wonderful lawyers in this country that have contributed to where we are today. However, we have a problem. They say where there is no vision, the Bible says, Proverbs chapter 29 verse 18, where there is no vision, the people do perish. Where there is no vision, the people perish, but happy are those who keep the law. We seem to have a problem that as our country continues to degenerate, as the level of sanity and equilibrium and rule of law in our country continues to go down, the next thing is to ask, where are the learned gentlemen? Lawyers are usually in the forefront of ensuring a society, an equitable society, ensuring that the dignity of everyone is respected, including that of the handicapped and the poor, defending the poor against the excesses of the rich and the powerful. Now we see our country continually going down the drain, and we see a situation where somebody steals a goat. According to the statutes, according to our criminal law, the person is maybe 3 months jail or whatever. Within 1 month, the person is prosecuted and condemned and thrown into jail and forgotten there. And people steal ₦1 billion, 10 billion. And for the next 10 years, it is being dragged. In fact, it may take 5 years and the case is not actually properly heard. We are still dealing with preliminary objections and whether this judge is qualified to hear the case or not, and so on and so forth. I think that this is, my opinion, fundamentally unfair, and I am back to the issue of lawyers. What is the role of law? What is the role of lawyers in transforming a society from a jungle to a civilized society? Prof.
Thank you, Father, and thank you for giving me the opportunity to interrogate some of the issues that you have raised. Firstly, is for us to have at the back of our mind that there is a clear distinction between the lawmaker and the role of the lawyer as part and parcel of the adjudicative system that we have. More often than not, it is difficult for people to draw this basic line of distinction. The beauty of law as law rests and depends squarely on the law that is available, the law that has been made, the law that is given. And whose responsibility is it to give these laws and to make these laws that will define the character of any system? More often than not is the legislature. So the lawyer is not part of the legislature. The lawyer awaits the legislature to make these laws that define the society to a very large extent. The law that obviously interprets the dynamics of society, because generally it's perceived that the society is more dynamic than law, and law is constantly playing catch-up.
Yeah.
Now, having made the law, and there is need to interpret the law, together with the judges, as part of the adjudicatory system, the lawyer comes into the fore. And that is where the role of the lawyer begins, so to speak. Now, have the lawyer been able to discharge his responsibilities equitably and adequately, as the case may be? Many may say no, but the lawyer works within the ambit and the context of the law that is available. I know it is difficult for people to appreciate this, and that's why occasionally you find people saying that the lawyer is a liar and the rest of them. But mark you also that apart from the substantive law, there is also the procedural law, which are rules or guidelines that comes from the substantive law themselves, which also guides the way the cases are handled and are adjudicated. And that brings me to the issue of what did we inherit? We never started law in Nigeria.
Okay.
We inherited law.
The British
most
law,
of our people trained in the early days, most of them trained in Britain, either in the Inner Temple or the Grace Temple or the Middle Temple, as the case may be. And a good number of people that train in some of these inns never even passed through the four walls of the university. So it was just a matter of go there and internalize some of the basic principles and the rules, and then you are called to bar. So to that extent, you will find that the issue of deep, profound scholarship as far as law is concerned was not even there at that point in time. Distinct from what obtained in continental Europe, where truly law was a university course and people stayed there and interrogated many issues and digested a lot, as the case.
So you mean that some of our earliest lawyers actually did not do a university degree in law?
A good number of them who were there maybe in the 40s or thereabout may not have passed through a university, because at that point in time the universities were not well established for purposes of law. So as the case may be, and going down as the case may be. But all I'm trying to say is that it is only when you're able to grasp the basics and the history of certain issues, and that's when you're able to examine them critically and understand them properly. And the point I'm trying to make is that the system that we have in Nigeria is called the adversarial system. That's what obtains in England. That's what we inherited. And that is what we still operate. The adversarial system makes it possible for you to see the two parties as adversaries.
Yes.
And more often than not, the judge is made to stay distant. Neutral, distant, aloof from the dust of conflict, which is the arena. So slug it out, both of you. At the end of the day, I will give judgment. I need not even intervene. So two of you are the adversary. I'm just like an umpire. That wasn't and is still not the position in continental Europe, where they have the civil law as opposed to the common law we practice. And for me, I feel that the tragedy of our system rests squarely on the adversarial system. It is only when we're able to tinker, and that's what some of us have been proposing over a period of time. We must tinker with that. To
do some major law reform.
Yeah, to do some surgery that will take us away a little bit from the adversarial system.
Is it the adversarial system now that you will blame for what appears to be a system that is more on technicalities of law than delivering justice?
Well, to an extent, one may also posit that to a very large extent, the whole concept of justice, if properly interrogated, finds expression better in the continental system than it is in the common law. Yeah, because the judge is truly part and parcel of the process, where the judge will be well disposed to say, no, counsel, this is not the correct thing.
Yes.
My own research tells me that this is the right thing.
By our system, the judge is even if he saw the guy steal the goat.
No. It is even a basis of appeal for the judge to intervene and intervene so deeply.
Yes.
So what we are trying to say is that you don't blame the lawyer. You blame a system And it is a system we are finding difficult to reform or amend. And maybe many people don't even understand it clearly, that apart from the adversarial system, there is still another inquisitorial system that operates. Now, some of our submission has always been, why not bring the two today together, an amalgam of the two? And that brings us to that question of stealing a goat and stealing...
because that's important for me.
Yeah. What does our constitution say? Again, premised on the adversarial system. Our constitution say that in criminal matters, you are presumed to be innocent.
Until proven guilty.
Until proven guilty.
Yes.
And beyond that is a standard of proof, which is also almost unattainable.
But does that not apply equally to whether somebody stole in the local government 5,000 or somebody steals 5 billion?
Well, again, the scenario may be difficult to capture and not as easily as put, in the sense that the standard of proof says you must prove beyond reasonable doubt.
Yes.
In any way you want to look at that, it is a very tall order. And why I said that the scenario may differ. Stealing a goat and establishing that you stole a goat beyond reasonable doubt may not be very difficult. But to establish that you stole 1 billion naira beyond reasonable doubt may be difficult. In the era of information technology, in the era where you must capture from the banks what has transpired, in the era where you may need an accountant to come in and establish truly that money passed through the process, and so on and so forth, you find that establishing beyond reasonable doubt in such a scenario may be a little bit more difficult. Fine, lawyers may also have to play some of their obvious games and machinations,
and they have quite a lot.
Even at that, the nature of our criminal justice system, beyond reasonable doubt, and you must be presumed to be innocent, does not seem to help matters. Whether it should be turned the other way around, just like in the inquisitorial system, where you are even presumed to be guilty, unless you're able to establish.
What system are they operating in Japan and in some of these
most
other
of
countries?
those countries are inquisitorial. Civil
yeah.
law.
Yeah, because I am aware that public officials that are guilty of corruption, within 1 month, the prosecution is ended and they are thrown into jail.
More often than not, it is for you to try to extricate yourself from a presumption of guilt. You're already presumed guilty because the evidence is concluded. You are presumed guilty. So extricate yourself. So the burden of proof is more on you rather than the burden of proof that is on the prosecution.
With what you are saying, what it means is that we have a major challenge.
No. It's going to be fundamental. But it is
major
important
challenge.
that people should understand that what we have is not a one-off. It is not universally applicable.
Well,
that we have an option. And it is for us to determine whether, if we have tried this option for a very, very long time, and we are not comfortable with it for whatever reason, is it not time we look at the other one? Or better still, can't we have an amalgam or a hybrid of two, so that at the end of the day, whatever comes before us, we can now say justice has been done.
I am all for major surgical, as you say, surgical operation in our legal system.
Precisely.
But we are running a legal system that is taken from Britain, and the UK.
Yeah.
But I don't imagine that they have the kind of problems we have, where somebody is accused of corruption and for the next 10 years, they are still doing preliminary objections.
Well, we may not, just because you cannot take away the lawyer from the society or the environment in which he finds himself. It's difficult. There's no denying the fact that the institution in Britain and the agencies and all the personnel have well been developed. I think we are still trying to come to terms with some of these things.
Where is the human exploitative tendency? Where is the human mischief? Meaning, we have a system, as you say, adversarial system. Isn't it perhaps the case that this is being exploited by a certain category of lawyers and judges against against the common good, against the common interest of Nigerians?
No, I wouldn't put it that way. I would rather say that people are adhering strictly to some of the tenets and the principles and the rules. But I'm not saying that to adhere to the tenet is wrong. But to rebuild the system is what I am all for. But if the issue is that the law has said you must do this, you must do that. If I try to adhere to what the law said that I have to do, I don't think I'm doing anything wrong. Because at the end of the day, it's still the rule of the law. But if fundamentally the law is defective because of the process and the procedure that throws up the law, then we have a major problem.
Do we have a dimension of the problem? Is there a dimension of this problem that is about weak prosecution in this society? Because when I, as a layperson, when I watch these cases on TV and so on, it appears that those accused, especially of things like corruption, are able to marshal more qualified, more capable lawyers to their defense than the people who are prosecuting them. Because you see, you talked about the adversarial, meaning you bring the two lawyers and let them slug it among themselves. When you have government anti-corruption agencies, government agencies have certain category of lawyers, of a certain level of lawyers. And then those who are accused come with a certain category of lawyers that even intimidate the judges.
Well, I believe that is a misconception, and I don't think I'm quick to consider
or let me say capable of intimidating. Maybe
it depends, because as far as I'm concerned, when a lawyer, and we are in the business of training lawyer, when a lawyer is well trained and well equipped, it is immaterial whatever title the other lawyer comes with. Because at the end of the day, it is your research capability that is important and not the title that you bear. Once you're able to stoop to read the basic issues, understand the technicalities, and able to draw up the relevant case law to back it up, I believe that you are home and dry. So whether you're a senior advocate or whether you're a professor is immaterial, because somebody else is capable of doing his work. So when people say, oh, because he came with a barrage of senior advocates and the other lawyer will be intimidated, it doesn't hold.
Well, we are talking from a point of view of the human reality.
No, well, by far people are likely to think that way. But I am saying that no, for any well-groomed lawyer, even if you are 3-4 years, you can hold your own. Forget about the razzmatazz and the other playing to the gallery that may come with the fact. The important thing is that a lawyer can hold his own against any. So to that extent, one can say without fear of contradiction that no, it is not the problem of the balance of lawyers. No, it is a problem of the young lawyer who is prosecuting still having that burden of proving the case beyond reasonable doubt. Because the burden is now on the young lawyer.
Where is the human element? Does the human element not have a part to play? Is it just the system that we inherited, or that we could have inherited that same system, but that another set of human beings could have operated it slightly differently?
Well, you see that brings us to the issue of law and morality.
Correct.
And occasionally law and religion, as the case may be. It is always important that law should have a human face. Our law should be seen to be given a human face in all its ramification. Even at the point of making the law, to what extent would law internalize morality? Or even in the application of law, would you still bring morality into play in the process of trying to balance out certain things? Fine. This is just an area that dominates jurisprudence as far as students of jurisprudence are concerned. And people are well taught about some of these things. And the schools of jurisprudence will always prepare the lawyer to know that there comes a time the issue of given law a human face, maybe through the injection of morality, will always be there. In the international law sphere, I think that plays out very well. And you can see from the Rome Statute and what the ICC seem to be doing, that certainly we have come a long way, starting from the time the Nuremberg trial took place to what is happening now through the instrumentality of the Rome Statute. But again, going forward, even in our own jurisdiction, mark you that apart from law, way back in England, when things started going bad, that equity, what they call the doctrine of equity, came into play. What did equity come to do? Equity came to give law a human face, because the harshness of law was getting too much, and the issue of equity is still very much with us. And apart from equity trying to dilute the strictness and the harshness of law to a very large extent, the issue of morality that I mentioned is also part and parcel of it. But in morality, we must now look at the issue of judicial discretion, the exercise of judicial discretion. Judges are expected to exercise discretion in so many matters. But it is said that if judges are exercising discretion, they must exercise discretion judiciously, as the case may be. Judges also have inherent powers. Lest in all these are just pockets of morality, whereby judges are supposed to, in interpreting the law, also make sure that things are given a human face. But also in the conduct of cases, they should also make allowance for that. When you see that a lawyer is obviously being intimidated or is not showing such competence and capacity or capability as one should expect, it is the responsibility of the judge to intervene and see how you can just guide the young lawyer to obviously stand on a proper footing and be able to...
When they say the law is an ass, is it this... because you see, I hear you speaking... one impression I get is that the law is one ass there that we are stuck with. And I, as a priest, I'm concerned with morality. I'm concerned that actually law is supposed to be at the service of morality, in the sense that law is supposed to be at the service of ethics and morality. Now, when a society is configured in such a way, and the practice of law in a society is configured in such a way that we can have one governor after the other who are found to have no cases in Nigeria, and just crossing the border in another country, they are thrown into jail. And yet, the same Britain is the one we inherited this same law from. Then I'm saying, the point I'm trying to make is that, isn't there greater responsibility on the persons who are priests in the temple of law than perhaps you are giving credit to?
No, there are so many comparisons that we cannot make effectively without putting everything into context and in proper perspective. Maybe the information available in Nigeria and what the prosecution has at its disposal may not have been adequate to prove a case beyond reasonable doubt, and I keep emphasizing that. But if within the four walls of a particular jurisdiction and another country, they have been able to make their documentation and their investigation has been so rich and well put together, it becomes easier.
I'm getting that point now.
It becomes easier for them to establish their case beyond reasonable doubt. So it's still the same beyond reasonable doubt. But maybe the process of documentation, the process of investigation in one country appears to be better than the process in another country. That is not the responsibility of the lawyer. The lawyer doesn't investigate. The lawyer only prosecutes. So if I'm armed with inadequate information, you don't expect me to achieve an objective which somebody elsewhere in another country can achieve because of proper investigation, as the case may be.
Prof, what you are implying is that the development of law and the prosecutorial system in this country is still at a very low level.
No, we are still developing. We are still developing because now a lot of capacity has been built. A lot of capacity has been built in so many of the agencies charged with the responsibility of investigation. And if we can now see that they're doing a good job with their investigation, as I imagine they are doing, now it becomes easier. And you can see that convictions are now gotten because people can now... So they trace money that has been taken away. They follow it up to know where the money has landed. They know when the money has landed somewhere else and has moved into an account, and they trace the account it has moved to, and it becomes your account. At that point in time, you are nailed. It becomes difficult. Hitherto, maybe some of these things were not possible, either because we have not developed electronically to that point, just like they possibly will do in England, or something. The people, the personnel were not properly trained to know that if you trace it to this point, the next thing is to see where it has ended. Now we are getting that.
If we are going to spend so many years, so many months, so many years, and so much resources before we can nail one person who did, committed a crime, I'm wondering if we shouldn't think of another kind of system.
No, Father, what I'm even worried about is as it affects the church.
Yes.
It affects the church, and that is the advocacy I would want us to take up.
Yes.
How come that people come to the court and swear by the Bible, and the next minute they are telling lies?
On that note, we would close this program, and then I will definitely have to have you for a second segment of this program, because that introduces a new dimension to our discussion. It was nice to have you, Prof.
Thank you very much.
Thank you very much.